And now, in another of our visits behind the scenes of courts and legal institutions, we've come to the country's largest immigration and asylum courthouse in central London. And we'll be talking to some of those who asked the tribunal to overturn far-reaching decisions taken by the Home Office.
When I was younger, I was caught up in some trouble, which I ended up going to prison for. And just before my release, I was told that the Home Office intended to deport me, so I had to seek legal advice.
That young man, who asked us to call him Jermaine, told us that the Home Office wanted to send him back to Zimbabwe, where he was born. But he's been challenging that decision at the tribunal. How old was Jermaine when he came to Britain as an asylum seeker?
I was 5 years old when I left Zimbabwe.
Do you have relatives, friends there?
I don't have any relatives that I know of or I'm in contact with, and no friends that I can remember.
How did you feel when you were told that you were being sent back to the country you left when you were 5 years old?
It was kind of traumatic, to be honest, because there was no recommendations by the judge that they should recommend deportation, and I was young, I was 17 at the time, so I just got a letter one day to say they were pursuing deportation.
And was there a hearing at the immigration tribunal?
Since I've been released from prison, I've had multiple hearings, but they've all been case management hearings, so nothing has been established.
So are you still waiting for a final hearing?
I've finally been given a court date, so sometime this year. The process started in, let's say, 2012, and I've only been given a court date in 2019. Being in prison was stressful enough. Although it was necessary for what I did, you feel like you've been punished, and now it feels like I'm facing further punishment for what I did when I was a child. Now I feel like I'm adult and I've been rehabilitated, but yeah, I still face further punishment.
Why would it be punishment for you to go back to Zimbabwe?
I fear possible persecution. So for the reasons that I initially came to this country, there was issues with the government and my family, which put my family in harm.
Do you have family here in England?
All my immediate family's here. I do not know of any family that I have back in Zimbabwe. All my family, as far as I'm concerned, are here in the UK. My life is in the UK, and I see my future in the UK. I was nurtured in this country. I grew up in this country. Everything I know is this country.
Jermaine's solicitor is Sofia Dushinska from the law firm Duncan Lewis. She told me that the Home Office was now seeking to revoke her client's refugee status, and trying to get that decision overturned has taken him many years.
The reasons why his case has taken as long as it has are because in a revocation case, UNHCR is asked to comment on whether it would be safe to return someone to a country where they had previously fled persecution.
UNHCR is United Nations High Commissioner for Refugees.
That's right. In a revocation case where the Home Office is trying to take away someone's refugee status, they're always asked to comment. I have to say that mostly they comment negatively that the refugee status shouldn't be revoked, and the Home Office takes no account of that and makes the decision anyway.
Some of our listeners may think that 17 is old enough to know what you're doing. If you come to this country as a refugee and you commit a crime that's serious enough to get you sent to prison, well, you deserve to be sent back because you've abused the hospitality of this country.
I recognise that as a point of view, and I think that every case has to be considered on its facts. Every case is individual. If a child has been here since the age of 5, they've grown up in our environment, they've grown up with all of the influences that a London child would come across, our schooling, our influences, and I think that it's quite difficult to say that this person does not belong in this country anymore when perhaps the reasons why the crime was committed are from the environment that they have been placed in. These are very difficult arguments, and every case should be considered individually.
Jermaine's case will be considered individually by an immigration judge sitting at a tribunal centre like Taylor House. This is a large modern court building in central London, and it's home to what's called the first-tier tribunal. When you head inside, you're directed to a waiting area where there's a notice board telling you which judge will be hearing your appeal, if everything works as it should. There are around 50 people, mostly appellants but also lawyers, sitting in this waiting area. There are 27 courtrooms in the building, but there's still a backlog of 10,000 appeals. About 1,000 of those are people who have been ordered out of the country following criminal convictions. Others are people who are appealing against a decision by the Home Office that they should leave the country.
I'm Russell Campbell, the resident judge at Taylor House, and we're stood in Court 2, which is empty at the moment. What you can see on the wall to my right is the Queen's Arms and then the judicial bench. And then just in front of the bench we have a place for the representatives to sit, the appellant's rep on one side, the presenting officer for the Home Office on the other, and then the other bench is for the appellant and an interpreter and witnesses if need be.
Let's go and have a look at what's happening in some of these courtrooms. It's lunchtime and I've just come out of a bail hearing, quite unusual because the man in custody is from an EU country in Eastern Europe. He has quite a long criminal record, and the question is whether he should be in custody or on bail while his immigration status is decided. It was quite unsatisfactory because the Home Office lawyer couldn't get online to check his criminal record. His defence lawyer didn't have the witnesses because they'd been allowed to go. They'd waited all morning, and the judge has adjourned the hearing while everything's sorted out. I've just been watching an asylum application. This is a man from Afghanistan. He was being questioned about his evidence. He said he had letters from the Taliban. His family had all left Afghanistan, and he was concerned that his life would be in danger if he had to go back there. The judge said she would give her decision at a later date. At his solicitor's office in Harrow, I met another man from Afghanistan who's challenging the Home Office. Abdul, as we're calling him, told me he was trying to bring his teenage sisters into the UK.
Yeah, I came to see my lawyer because I was going to sponsor my sisters under 18 years old. I've been trying to bring them over here to live with us as we don't have anyone in Afghanistan to look after them.
To begin with, the Home Office turned you down?
At the beginning, yeah.
Abdul came to me when he found out that his sisters were alive in Afghanistan.
Tamana Aziz from Duncan Lewis Solicitors said her client Abdul had asked the Home Office entry clearance officer to let his sisters into the UK as his dependents.
We made that application. Unfortunately, the application was refused, and one of the main reasons were that there was insufficient evidence that they were siblings and they were sisters of Abdul.
So his solicitor challenged that decision before the Immigration and Asylum Tribunal in London.
While that appeal was pending, I advised my client to get DNA evidence because of the fact that there were no documentary evidence showing them as siblings. Everybody knows what went in Afghanistan, so it was difficult to find birth certificate. And after the DNA evidence was taken, the report came to me, I actually wrote back to the entry-clearance officer with evidence, submitting that they are siblings. You can see from the evidence. You should overturn the refusal and grant them entry-clearance to come and join their brothers in the UK. Unfortunately, no such review took place, and we had to then go to the First Year Tribunal.
The process took a bit of time, but we had to go through that process.
Months?
More than a year.
But in the end you were successful?
Yeah, at the end we were yeah.
And so you must be pleased?
Yeah, of course, these things take time, but and also there is challenges. You have to go through it according to the law, and I'm pleased about the judiciary systems in the United Kingdom.
Even though there are lots of courtrooms at Taylor House, lawyers soon found out that Law in Action was sniffing around. I've just come out of Courtroom 1 at Taylor House. As soon as I went in, a barrister representing the appellant, an asylum seeker we understand, immediately applied for the judge to sit in camera, in other words, in private, with the press and public excluded. She said there were serious allegations being made against the Secretary of State. The judge asked her if she wanted to make her application in private. She said yes. We left the court. I'm now waiting to find out whether I'll be allowed to observe this case. I waited outside court for a few minutes and the judge beckoned me in. He explained that these courts normally sit in public, although he had made an order preventing us from identifying the appellant because of the risk he faced. This is an asylum case after all. Then the judge said he was going to grant an adjournment. The reason for that is that only yesterday the Home Office had disclosed a document. We don't know what this document says, but we do know it was written more than a year ago, and the appellant's lawyer said she needed time to study this document and respond to it, and the judge said he'd adjourn the case. Immigration lawyers say this sort of thing is far from unusual. Crucial documents may not be disclosed until a case officer passes the file to a Home Office presenting officer, often just a day before the hearing. And what happens in the courtroom? Well, we're not allowed to record the proceedings, of course, but Jane Haybrook, a barrister at Goldsmith Chambers who represents people appealing against Home Office decisions, told me how it looked from her side of the courtroom.
What happens is you have the judge who introduces themselves, who introduces the procedure for the day. Generally speaking, they make it clear that they are independent of the Home Office, and they go through what format the hearing is going to take that day. They then ask each of the parties, so myself and the Home Office representative, if there are any issues, preliminary issues that need addressing, and then from that point onwards I introduce my client, introduce their evidence. After that, the Home Office cross-examines the appellant on the basis of what's in their witness statement, based on what their reasons for refusal were in their decision letter. And sometimes that can take 15, 20 minutes. Sometimes it can take 2.5 hours. 99 times out of 100, there is no decision given on the day. The reason for that is that immigration judges must put their decision in writing and give proper reasons why they're making their decision.
Jane Haybrook explaining why cases take so long. Tamana Aziz, the solicitor we heard from earlier, is concerned about these delays.
The process has got its positive points and negative points. I think the long wait for a hearing, that is a bit of an issue. Sometimes we go to the tribunal with no notification that we're on float list, and as soon as we attend, you're told by the reception that you're on float list, which means that you have to just wait there for the entire day till a courtroom becomes available and the judge becomes available to hear your case. So these are the smaller issues, but overall, the way I've been dealt with by the immigration judges and by the tribunal, they're quite helpful and they assist you as much as they can.
And they have no problems about finding against the Home Office. They're independent.
That's a very positive point, and for my clients, when I advise them on what's going to happen at the tribunal, the first thing I tell them always is, look, you are going to be heard by an independent immigration judge who will make his own decision based on the facts, based on law, based on what you produce and what you say. So don't be afraid. You've got a chance now to prove yourself that you're right. And I think that it's brilliant.
Tamana Aziz, and her concerns about delays are shared by the Courts and Tribunals Service, which runs courts across England and Wales. Their answer is a £1 billion reform project that will gradually replace paper forms with online applications, reducing the number of hearings needed. But Michael Clements, president of the first-tier Tribunal Immigration and Asylum Chamber, told me that reform would take time.
We're working slowly because we have what's known as an agile project. So we're starting small, building on it, and if something doesn't work, we look to do something else. So we hope that the reform project will produce efficiencies and savings and produce better justice for the appellant and the respondent.
I dropped in on a case this morning and the judge had to adjourn it because the Home Office had produced a crucial document only last night and the appellant needed more time to deal with this document. I don't know any more details than that, but it struck me as rather disturbing.
Well, we do find that both the Home Office and the appellant's representatives do sometimes produce papers on the day of the hearing. This is something which is very troubling because it will quite often necessitate an adjournment, and that cannot be in the interests of the parties. We are moving forward on the reform project to ensure that all paperwork and all issues are disclosed right at the beginning of the process rather than at the hearing.
The problem, of course, with having to adjourn a case because a document's been produced on the day is it wastes everybody's time, in particular the judge's time. Is there anything you can do about that?
Most judges would like to think, well, it's the end of the day if something's adjourned, but unfortunately it's not. We run a very heavy float list at our hearing centres, so if something is adjourned, then the judge will be expected to pick up other appeals to deal with.
Despite all the pressures, Judge Michael Clements tells me he has a very rewarding job. The challenge immigration judges often face is working out whether there's a needle of truth in a haystack of exaggerations.
It's very easy to exaggerate and to embellish an account because it just sounds better. And the judge's job quite often is to work out what is reasonably likely. That's why country of origin information reports, US State Department reports, reports from Amnesty are so important to enable us to weigh up and work out exactly what the appellant is saying, whether it's tying in with the background evidence.
You and your judges have to be quite aware of the political situation around the world, really, don't you?
Well, I tell all my judges that we go on a world tour every day. You may well be sitting in the morning in the arid plains of Helmand province and in the afternoon in the lush jungles of the Congo.
Judge Michael Clements. And if you want to be an immigration judge, well, I'm told there are quite a few vacancies at the moment. We're about to leave a vacancy in your listening schedule for a couple of months, as this is the last Law in Action in the current series. But I'll be back with more behind-the-scenes visits every Tuesday in June. Do join me then. You've been listening to Law in Action, presented by me, Joshua Rosenberg. My producers were Neil Koenig and Diane Richardson.